Article 3, Section 49 of the Missouri Constitution declares that the people reserve the power to propose amendments to the Constitution by the initiative independent of the General Assembly. It is not a grant of authority, it is a reservation, and it's the only reservation of power in the Constitution as far as I can tell. The question is whether the court system is going to honor the will of the people, their reservation of that power, or whether we're going to allow a small group of people to take that power over an issue of form, over a statute that covers things like how large the paper size should be when one exercises the petition, or whether they should be of the same size, the pages. This is a big deal. The court will send a message today, hopefully today, about whether in our little corner of the democracy, the government will honor the will of the people or whether we'll have it snatched away. My clients and I are here to speak for 254,000 Missourians who the Secretary of State agrees and has verified were lawful voters of the state of Missouri and signed an initiative petition to ask their fellow citizens to vote on whether to amend the Missouri Constitution this November. The issue on which they asked for a vote, reproductive rights, is no doubt a controversial one. The court may take judicial notice. But the fact that it's controversial does not mean that the courts and the state officials should cast aside the fundamental right to have that vote. Nor should we cast aside the rules and protections that this court has held sacred around the initiative petition for my entire life and before. Those processes protect us all, whether we call ourselves pro-choice or pro-life, or whether we decline to accept either of those labels. And they protect folks who aren't part of this debate, but want to have other debates about things like whether to raise taxes or whether to have marijuana legalized. You may not like the initiative petition process. When I say you, one may not like the initiative petition process, and we're going to have that debate probably soon about whether initiative petition is the right way to run a government. But today, the Constitution guarantees the right. Throughout history, this court has been called upon to protect the initiative petition, from the Hancock Amendment to right to work, to taxes on tobacco products, to abortion. You've held fast and acknowledged that reservation of right to the people and their ability to amend the Constitution, importantly, independent of the General Assembly. That's the language. And the need for you to do that, the need for the judicial system to protect the people from interference in this process, is at its greatest when the subject matter is highly controversial. And this matter, now known as Amendment 3, might be the most controversial one yet when you look back. Of course, to other people, theirs was probably the most controversial. The courts, including this one, have already been called upon about this matter, about Amendment 3, to protect the process against interference by elected officials opposed to the goals of the measure. And it's okay to be opposed to the measure. That's the debate that makes democracy work. They can go out and have that debate and discussion, but the time and the place to talk about whether Amendment 3 is a good idea is in November and the campaign leading up to November. It's not here in this courtroom or in the courtroom down the street in the Circuit Court of Cole County.